probably the most common question people will ask me is, what is an estate plan and do I need one? And the answer to that is, once you become a legal adult, every person needs an estate plan. It's just a matter of to what degree and form do you need one. And the reason for that is once we all reach the age of 18 and become an adult, nobody legally has the ability to make your financial or medical decisions unless you give them your legal permission. And there's two ways of obtaining legal permission in the state of California. So everything we're talking about today is all California specific. So it is important to mention that every state in the United States has their own individual estate planning laws. California is one of a few community property states, whereas the majority of states in the United States are separate property states. So just know, if you were to retire and if you move to a state that borders the state of California, most of our neighboring states also tend to be community property states. So our laws are pretty similar with our neighboring states. But once you hit New England in the Midwest, all of those states by and large are separate property states, which basically means if you're a married couple in most of those states, you would have your own separate trust and your own individual estate plan. Whereas in a community property state like California, a married couple will have one trust as a married couple versus having two trusts between a married couple. So once you turn 18, the way that you obtain a person's contractual permission to make medical and financial decisions is either going through a court process called a conservatorship, which with Britney Spears being in the media lately, conservatorships were brought to the public attention. And unfortunately, that was a very bad example of a conservatorship. But really what a conservatorship is if I'm hit by a drunk driver and if I lose my capacity, and if I don't have a legal document in place identifying the person or persons that I would trust to make my financial and medical decisions, then the court will appoint somebody to make those decisions for me. So in San Diego, those conservatorship hearings are heard through our probate court, which is located in downtown San Diego. They just built a new court down there. It is absolutely beautiful. So if I were hit by a drunk driver and if my taxes, for example, needed to be filed, the only way my husband, even though we're legally married, could sign my name on a tax return is if I either gave him my durable power of attorney or if he petitioned the probate court to become my conservator. So a conservator is the name given when a person is appointed through the court process. When you create an estate plan, two of the most important documents that you're going to create are your durable powers of attorney. And the word durable basically implies a triggering event where you lose your capacity. So in my durable power of attorney, if I were hit by a drunk driver and if it was April 15th, my durable power of attorney gives my husband my legal permission to sign my name on our tax return. So he would have my legal permission to step into my shoes and to be my financial advocate. So because I have that document in place, and because I made all those decisions while I have had capacity, we avoid that court conservatorship process. So one nuance about an estate plan is sometimes people will jokingly make that joke of, oh, what do I care? I'm incapacitated, or oh, what do I care? I'm dead. But in my opinion, if you're not going to trivialize these real serious situations, you should care, because amongst our family and friends, not everybody is necessarily like-minded when it comes to money management. So wouldn't you want the ability to name amongst your family and friends who that first, second, and third choice is to be your financial advocate? Because honestly, if I lost capacity, I'm in a very vulnerable position and situation in my life where I would want to make sure that the individual I chose to be my financial advocate is like-minded, is trustworthy, is somebody that I know would take good care of me, because now I don't have the wherewithal to ask the questions or to look at my bank account. So once you turn 18, whether you have assets or not, you should have a durable power of attorney for financial affairs in place so that if you lost your capacity, your loved ones wouldn't have to go through this court conservatorship process. A medical directive is the other type of durable power of attorney. It's a very important document. Terry Schiavo brought that document into the limelight about, probably 35 years ago. because she sadly was hit by a drunk driver when she was on her way home. Her husband thought that she would not want to be on life support, being in a permanent vegetative state. Her parents, for religious reasons, did not believe in the withdrawal of life support. Sadly, these three very well-intentioned people battled all the way up through this to the Supreme Court of the United States, which, trust me, if you have a case that's being heard by the United States Supreme Court, you've spent a lot of money, you've spent a lot of time, and unfortunately, there's usually no win when it comes to these types of court cases. So nobody walks away necessarily feeling justified or that they've won. Instead, oftentimes people end up walking away with a lot less money in their pocket, and they feel deflated, and the relationships are oftentimes irreconcilably broken. So in the Terry Shiva situation, one of her college roommates came before and gave testimony that when they were in college at a bar, Terry had made a comment that if she was in a permanent vegetative state, that she did not believe that that was any type of quality of life, and she would not want to be on life support. So based on this college roommate's testimony from many, many years prior, the Supreme Court gave her husband permission to withdraw the life support. He then cremated Terry, which her parents were also against. They wanted her to be buried. And to this day, if her parents are still living, which I'm not sure if they are, there was never a place for them to go to visit, which was extremely painful. So had she had a healthcare directive, all of that could have been avoided, which I'm sure all of them would have preferred. And the nice thing about a medical directive is you don't have to have an attorney prepare this document for you. In fact, most of your medical insurance companies have a free form that you can complete yourself. It is one document in an estate plan that can either be notarized or it can be witnessed by two disinterested witnesses, which a disinterested witness is somebody who's not being named in the document. And ideally, it's somebody who's not related to you. So if you called ucsd Healthcare, I believe you'd probably call the business office to ask for their healthcare directive. If you just filled that out in your own handwriting and asked your neighbors to come over and be a witness, because usually your neighbors are perfect disinterested witnesses, that would be a legally binding document. So really the benefit of a medical directive is you're going to name people to be your medical advocate if you lack capacity and couldn't advocate for yourself. It's prudent in making these decisions to always name 3 to 4 people, because there's always a possibility that the first person listed might have been in the same accident with you, so now they're not eligible to act. If the second person listed is out of the country or not available, it's always good to have at least 3 to 4 people deep in these documents. And when you name individuals in any of these estate planning documents, you are just nominating them. So just know that any person listed has the ability to accept or decline the nomination. And once they accept the nomination, there's also the flexibility of resignation built into these documents. So if at any time life happens and somebody wants to step down for any reason, they can. And again, that's another reason why it's good to have 3 to 4 people in these documents. I've drafted documents where people have listed as many as 8 to 10 people, but that's kind of not that common. Usually you're going to name 3 to 4. And just know when you create a medical directive, you want to make sure that you photocopy your medical insurance card and attach it to the back of that document. I say the front and back of the medical insurance card because usually your phone number for the healthcare insurance company is on one side and your insurance policy number is on the other side. And then I would also make sure that if the document doesn't prompt you to include the contact information of the people that you're nominating, that I would go ahead and type that up and attach that to the medical directive. So now you have a medical directive that is a legal document that includes who your medical advocates are. Typically, you include your preferences about burial preference, whether you prefer to be buried or cremated. You usually will also include information if you've already made contractual arrangements and have paid for some or all of that in full, so that your family doesn't duplicate payment for burial or cremation. You also want to include your preference about life support, whether you would want to be on life support if your doctors have concluded that you're in a permanent vegetative state, or whether you'd want life support to be withdrawn. In my medical directive, I wanted a window of time where I would be on life support. I think I said 3 to 21 days, kind of an arbitrary range, but still, I just wanted to give my family and friends a period of time to say their goodbye, to make whatever arrangements might need to be made so it didn't all happen too quickly. But I also didn't want to be on life support for too long unnecessarily. You can also give your loved ones your permission to make that decision about life support when and if it presents itself. So the nice thing about doing a medical directive is there's a whole myriad of options that you can choose. And your organ donation is probably one of the more important things that you also want to include your preferences on, because now with modern technology, there's so many amazing things that can be done with your skin, your cells, your there's just so many things. So I have some clients that are willing and able to donate organs and tissues, but for transplant purposes only. I have other clients that are willing to donate their skin to burn victims. Other clients are willing to donate their body to be a cadaver, which is so important. Whereas other clients will say that they don't want to be an organ donor, which is perfectly fine, or they might give their loved ones their permission to make the decision at the time, because sometimes people feel like since the family members live with the after effect of all of that, they are the best people to decide. Whereas other times people feel that because it's such an important decision that they don't want to burden their loved ones, because they view making family members make those decisions as more of a burden than a blessing. But every situation is different, which is why it's so important to take the time, in my opinion, to put these documents in place. So like I said, if you have, I know that Sharp, UCSD, and Kaiser, they all have their own medical directive. That's just a form that you can fill out. So if any of you don't have a medical directive and a durable power of attorney, those two documents are so important to have for all the reasons we just talked about. And for those of you who have that ARAG legal insurance, if you have, I think it's called family coverage, your adult children are covered under your estate plan, so they could put their durable powers of attorney in place through your insurance as long as they're at least 18 years of age. But I don't know what the cutoff age is, and sometimes it changes. So you should call ARAG and find out if your kids are covered, because if your kids are covered, why not have them go through your insurance and put their durable powers of attorney in place? So heaven forbid, if they were in a situation where they needed a medical or financial advocate, they could have all these documents in place, because they're so very important. Because without them, if these decisions needed to be made, you'd have to go through that court conservatorship process, which is a little slow, it's public, and it's not necessarily inexpensive. So having these documents in place, the other benefit, just to wrap this up, is when that situation happens, which is never planned, it's never convenient, you have these documents, which makes that transition a lot quicker. Whereas without these documents, when you have to have the court appoint somebody to be an advocate, because that is a public process, and because we only have 3 sitting judges in our probate court, oftentimes when we file a petition to open a conservatorship, it's usually about a 2-month wait until we get that first hearing. And then it's usually about 7 to 14 more days until we get the letters from the court that makes everything official. So getting a conservatorship in place doesn't always happen very quickly, and people don't always think about that, because why would you? I mean, most of us, in a perfect world, life doesn't happen and there's not a car accident or a medical emergency, but sadly, it's going to happen eventually to all of us. So having these documents in place is just such a nice peace of mind. And they are amendable and revocable, which means you can and you should review and update these documents about every 8 to 10 years, because the language in these documents does become stale, for lack of a better word. So just know, when you put an estate plan in place, it's usually a good idea to put on your calendar about 8 to 10 years after you've created the estate plan, that it's time to sit down and do a review and revisit the language in these documents. Granted, you can change these documents whenever you want. Updating successor trustees, financial advocates, and medical agents are the 2 most common changes people will make. Once your minor children become adults, you can take out all the language in the documents that pertain to guardians, because you no longer need that once your youngest child is 18. But on the flip side of that, just know that if there is language in your estate plan that's no longer legally relevant, those situations just don't trigger. So it's not as though having outdated documents in your, or outdated language in your documents invalidates your estate plan, because it doesn't. If something's in there that's not legally relevant at the time of your incapacity or death, then those situations just don't trigger. So I just like to mention that because sometimes that's a concern for people. So when we talk about estate planning, really the heart and soul of an estate plan is a revocable living trust. And there is a lot of misinformation out there about trust. So let's talk about that. So in California, if I died yesterday, to not jinx anything, let's first talk about what happens if I don't have any estate planning documents in place. So when I die without a will or a trust, I die what's called intestate. So intestate is a legal term that's used when a person dies who does not have a legal document in place to tell the state of California who will be in charge of administering their estate and who their intended beneficiaries are. So if I died intestate, somebody from my family will hopefully petition the court to become my executor or administrator, because that's the term that's used when there's not a will in place. Once the court appoints the administrator, they then would have a legal duty to notify my beneficiaries that I've passed. They would have a legal duty to marshal my assets, which basically means they have to figure out my assets and debts. Legally, nobody can inherit until all my debts, taxes, creditors have all been paid and filed in full. And then the administrator would ask for court permission to make distributions. And at that time, once all the debts, taxes, and bills have been paid for, that is when the beneficiaries would inherit. So when you die in California without a will or a trust, the hierarchy of beneficiaries is going to go to your closest living blood relative. So if I died as a married person, California, under our community property laws, are going to give my assets to my spouse. But if I died as a single person or as a widow, then under California intestate laws, the state of California is going to give my assets to my surviving lineal descendants. So what that means is if I have 2 living children, they then would inherit my assets if I died as a single person, and they would inherit equally. If either of my children predeceased me, but if they had surviving children of their own, under the intestate statute, my surviving child would get 50% of my estate, and my deceased child's living children would get the other 50% divided equally between them. If I died without a spouse, children, grandchildren, or any living lineal heirs going down my bloodline, then the intestate statute is going to go up my bloodline, first to my mom and dad or to my surviving parent. Then it will go to my siblings, which only includes blood relatives and half. It does not include step. And then it would go to my nieces, nephews, great nieces, great nephews. And if we still haven't identified a living beneficiary, go up to the grandparents. Then we go to the aunts and uncles, first cousin, second cousin, third cousin, and so on. If in the very small situation that there is no living blood relative, then the default is that the state of California would inherit your estate, which in 20 years of practicing law, I have never seen that happen, not once. And there are companies that are called heir locators that are in the business of locating those closest living biological relatives. And I've only had one situation where a person had passed away and the gal that contacted me was unsure of the family lineage. So we hired one of those companies. And unbeknownst to her, there was a cousin of equal standing who was a 50% beneficiary. And we found that beneficiary through that heir locating service because her uncle had died intestate without a will or a trust. So just know, in the state of California, if you don't have a will or a trust in place, the state of California has one for you. The one really important thing to understand is when you're a blended family, under California intestate laws, your stepchildren are not included in that hierarchy. So hypothetically, if my husband and I are on a second marriage, and let's say, for example purposes, that I have 2 kids from my first marriage, let's say that he has 2 kids from his first marriage, and let's say that we have 2 children in common. If I died without a will or a trust, under the intestate statute, I have died intestate. So California is going to give my community property to my husband, which is going to make him the full owner 100% of all of our assets. And then when he dies, assuming he dies without a will or a trust, he dies intestate. in which case the state of California is going to give all of our assets to his biological children, which would include his first two children from his first marriage, our two children together. But my children from my first marriage are automatically not included in that intestate distribution, so they would be disinherited. So just know that in California, if you pass away without an estate plan, and if you are a blended family, you do need to have your affairs in order. Because otherwise, if you're a blended family, and sadly, if you passed away first, if your surviving spouse didn't put an estate plan in place acknowledging those children, then they would be disinherited, at least the stepchildren. And that applies to any relative under the intestate statute, a stepmom, a stepdad, a stepbrother, but it does include half siblings. So half siblings are included, adopted children are included, but it's the stepchildren that are not included. So the difference between having a will and not having a will is when you have a will, you've now taken the time to put a legal document in place. In that document, you've identified who the executors are, who the beneficiaries are. But the nuances, which a lot of people don't always understand, is that when you have a will in the state of California, your assets might still go through a court process called probate. So probate is a court process that occurs when a person dies, and it only is triggered when a person dies who owns real property that's not titled in a trust, or if they have over $166,250 worth of aggregate assets that aren't titled in the trust, that now will trigger probate because that asset doesn't have a beneficiary attached to it. So for example, if I have a house and if I died as a single person, and if that house was titled in my individual name at the time of my death, even with a will, that house will go through the court process called probate. If I don't have a house, but I have $400,000 in a bank account, and that bank account does not have a beneficiary attached to it, then because that asset is over $166,250, that bank account will trigger probate. And what people don't understand, which is really important, so when you have an estate plan, putting these documents in place is really step one of a two-step process. The second step in the process is changing the title of your assets so that assets are either titled in the name of the trust, or they name the trust as the pay on death beneficiary, or the one exception to that rule for retirement assets, you name individuals or charities as beneficiaries. So when you have a trust, that does not guarantee that we'll avoid probate, because it's how your assets are titled at the time of your death that shows whether or not we have to go through probate. So an example of this is when I became an estate planning attorney, my grandfather had his estate plan in place by an attorney in Riverside because he lived in Sun City at the time. And I ended up, just because I wanted to, I checked the title of his property because I wanted to make sure that his property was titled in his trust. Was not titled in his trust, but in his individual name. So I called my dad and I said, Dad, didn't Grandpa have an attorney do his estate plan? And my dad said, yeah, he paid a lot of money for it. The attorney said everything was in place. So my dad sent me all of my grandfather's paperwork, and in the paperwork was a letter from the attorney that explained how to put the house into the trust. So it's kind of surprising, but estate planning attorneys are not under a duty to put people's houses into their trusts. But if a house is not titled in the trust at the time of your death, even with the trust, we're going to have that court process called probate. And what people don't always understand is estate planning attorneys make a lot more money going through probate than they do doing estate planning. So the reason for that is when you go through probate, the probate fee that is charged is statutory, which means it's predetermined by law, and it's a percentage of the gross value of the assets that are going through the probate court. So if you have a house in San Diego County that's usually worth a pretty significant amount of money going through probate, on average, most probates in our county, the fees vary from anywhere from $7,500 to $25,000. So if you have a house, I can guarantee you that putting an estate plan in place, the cost of it is going to cost a lot less money than not having an estate plan and having that house trigger that probate proceeding. The other downside of going through probate, in addition to how expensive it is it is a public process. So if my estate went through probate, anybody could pull my file and see who's inheriting from my estate, where they live, their date of birth, social security number, and how much money they're inheriting is all part of that public process, which today with identity fraud, that is not a good situation to be in. So the other benefit of having an estate plan is that by avoiding this public process, you're keeping everything about your loved ones private. You're also saving a lot of money by not having to pay those unnecessary attorney fees and court costs. And your family will inherit these assets a lot faster if you avoid probate. So in the state of California, a probate has to be open under our state laws for a minimum of 6 months before it can be closed. But just like with the conservatorship, the same 3 judges that hear the probates are the same 3 judges that hear the conservatorships. And they're the same 3 judges that will hear guardianship matters and do the trial calendar for when estate plans are contested and litigated. So these 3 judges in our probate court have a lot on their plate. So just like with the conservatorship, if I file a petition to open a probate, it's usually about 2 months before I get that first hearing date. So when a person passes and if assets have to go through this probate process, those assets are basically frozen until the court date happens and until the court officially recognizes who that administrator without a will or who the executor with a will be, because legally you can't do anything with these assets until you have something called letters testamentary. And those are the letters that the San Diego probate court produces that acknowledges and recognizes that the court identifies you as the rightful legal person to administer that estate. So when a person passes away, assets that are titled in a trust are not frozen. Assets that have to go through probate are frozen until the person who is identified in the will, or if there's not a will, is recognized by the probate judge. Once that hearing occurs, it's a minimum of 6 months, but by the time you file the other documents that have to be filed in a probate, which would include the accounting to show the financial history of the estate, because the courts do want to see that the assets and debts and taxes and creditors, credit cards have all been paid in full. And then you file a final petition asking the court to give you permission to close the estate and to make final distributions. So generally there's about 3 court appearances that have to happen. So each time you're filing that paperwork, you're looking at about 2 months lag time before that hearing occurs. So right there is your 6 months. So most probates that we handle take anywhere from 8 months to a year and sometimes longer. And if a probate sadly is contested, then that's going to probably take at least a year, possibly 2, if not 3, because contested matters take a lot more time because there's a lot more hearings that have to occur in contested matters, unfortunately. So I just like to mention that because a lot of times, and I understand, people assume that once they put their estate plan in place, they're done. But I know that our firm, once we give our clients their estate planning binder, with that binder, we give them instructions that we call their homework. We can pull the deeds to properties and we can assist clients with transferring their properties into the trust, which is part of what you need to do. Timeshares we cannot usually assist with because most timeshare companies do their deeds internally. So for anyone who has an estate plan, if you own a timeshare, you do want to contact the timeshare company and ask them to retitle that timeshare so that it's titled in the name of your trust. And then corporate interests, if you're a business owner or if you have a rental property that's titled in an LLC, you always want your business ownership interest to be titled into the trust, but that's all. So your corporate credit card debt would be in the name of the corporation. Your corporate checking account would be in the name of the corporation. But if you're an S Corp or a C Corp, your stock certificate would be titled to you as trustee of your trust. And if you're an LLC owner, then your operating agreement would show your ownership member interest titled to you as trustee of your trust, because that's how we keep these corporations out of our courts. And then the one thing that, oh, and let me finish this thought, your taxable investment accounts would also need to be titled into the name of the trust or naming the trust as the pay on death beneficiary. So your taxable investment accounts, checking accounts, savings accounts, CD accounts, money market accounts should either be titled in the name of the trust, or if you bank at a bank that won't convert an existing account into a trust account, if you have the trust identified as a pay on death beneficiary, then that will keep that asset out of the probate court. So when you do this estate plan, after these documents are in place, you need to go to the banks and update your bank accounts, and you need to call your timeshare company and update how that deed is titled. And you need to make sure that that house that you own is put into the trust. And then going forward, if you refinance your house, you always want to make sure that the house stays in the trust, because sometimes during a refinance, the mortgage company will take the house out of the trust for the refi. So you want to make sure that the house closes in the name of the trust at the close of the refi, because sometimes, unbeknownst to people, their houses come out of trust just because that's part of what happens during these mortgage processes, and they don't know it because most mortgage companies don't feel they legally cannot give the legal advice, so they don't normally point that out to you. So you're in the process of refinancing your house, and unbeknownst to you, the house is no longer in the trust, and you sign all the paperwork, and now it's joint tenancy. Which, one nice thing about joint tenancy between a married couple is when the first spouse dies, you avoid probate because you still have a living owner. But when the second spouse dies, if they haven't caught that title is no longer in the trust, and if the house is not in the trust when the surviving spouse dies, then that asset will trigger probate. But one thing that you don't want to put into the trust as far as beneficiary designations are concerned are your tax deferred assets. So for those of you who have an estate plan that's maybe 10 years old or older, 10 years ago, the laws were very different. So all of us estate planning attorneys were saying name your spouse first if you're married and name your trust second. As far as beneficiaries on your 403Bs, 401Ks, IRAs, and simple. But you don't want that any longer because the laws do change, albeit slowly. And now the tax laws are such that you don't want any type of a retirement account naming a trust as a beneficiary, because it does create an unnecessary taxable event to those beneficiaries. One exception to that would be if you have a loved one who's on state or federal disability, and if you have a special needs trust, then there is language that's included in a trust that can minimize some of those adverse tax consequences, because anyone who's on state or federal disability needs to have these assets in a trust. They can't have the assets come into their individual name, or they're likely going to lose their benefits once their social security number is audited. So just know that 10 years ago, for those of you who have estate plans, if you named your trust as a beneficiary on a retirement account, and if you don't have a loved one that's on state or federal disability, you should update and change your beneficiaries. Luckily, you can do most of that online, so it's super easy and convenient. And for those of you who haven't reviewed who your beneficiaries are in a while on your retirement accounts, no better time than the present. So definitely stay on top of who your beneficiaries are. You always want for retirement accounts to have a primary and a secondary. You always want to have too many beneficiaries than too few, because if you run out of living beneficiaries, there's a chance that that asset will trigger probate. So I think we've covered that pretty thoroughly. So when you put a trust in place, a trust is just a fancy word for a contract. So I have a marital trust with my husband. So between the two of us, if I'm hit by the drunk driver and if I lose capacity, through the language in my trust, I give my husband first, and then my loved ones second and third and fourth, the ability to step in and be my financial advocate when I lose capacity and I can't manage those trust assets for myself. If I were to pass away, I have a type of trust that would give all of my assets to my husband. And then when he passes away, that's when our trust becomes irrevocable, which is a fancy word for saying it's no longer changeable, because now the owners of the assets have passed. And that's when the beneficiaries of that document will vest. And in our trust, we have some age contingencies in place because our two children are still very young. They're still very immature. We're working on that every day, but we have language in our trust that if my husband and I passed, and if either of our kids were under the age of 35, then their monies would stay in our trust and would be managed by our successor trustee until each of our children turned age 35. While they're under 35, they can ask for distributions for their health, education, maintenance, and supports, or if they're off to college, monies from the trust can be used to pay their tuition, to pay their living. but that's all in the discretion of our trustees. So one really nice part of a trust that you don't have when you go through probate is when you have a trustee in place who's managing assets on behalf of a minor, there's discretionary powers that you give your trustee. So if my daughter, for example, was flunking out of college, my trustee could always tell her, hey, I'm going to pull this tuition payment and you're on your own until you bring your GPA up. So even though the trust authorizes distributions, it's the trustee who's the gatekeeper of when the kids get money and how much money they get. So we picked a trustee that when our kids are younger would basically tell them to go get a job, because we didn't want trust fund babies that are, just lazy and surfing and relying on inheriting money versus making their own way in this world. So when it comes to picking a trustee, you really want to pick somebody who's like-minded as you. I had a client once that was very wealthy, and she was bragging about how she, unlike her friends, is very careful with money and she doesn't spoil her children like her friends do. But she wanted language in her trust to make sure that when each of her kids turned 16, they got a Rolls Royce paid in full, which I had to really check my face to stay stoic, because that's not my normal, but it's her normal. To her, buying each of her kids a Rolls Royce at 16 was being conservative, whereas to me, buying my kids a used Honda Civic is more conservative. But to each their own, which is why doing an estate plan is so important, because it is individual to each of us, and each of us have our own circumstances and our own obstacles. I know that when I did an estate plan for one of my family members, there was some pretty big concern about drugs and a possible drug overdose. So we put language in that trust about drug testing and being drug free for a period of time before assets could be used, but making sure it was clear that monies could be used to pay for rehab should a beneficiary be willing to go. So there's a lot that you can do in a trust as far as parameters, distributions, contingencies. But once you're in the probate court, because we only have 3 sitting judges in our court, and because the state of California does not want to have the ability to have discretion, because when you have a lot of discretion, that's kind of the gray area of the law, and that's when beneficiaries can sue or can contest. So in the probate courts, there's really no discretion that's exercised. So if I died with assets going before the probate court, once each of my kids is 18, they legally are eligible to get all of that money, because the courts aren't going to manage that money or oversee the management of that money until my kids are older. So one downside to not having a trust, if you have younger beneficiaries or if you have beneficiaries with substance abuse, is those contingencies that you can put in place in a trust to really look after those issues, you can't put in place in a will, because the courts will not enforce them. So, quid pro quo, if you're looking at the cost benefit analysis of having a trust versus not having a trust, when you have younger beneficiaries, having a trust is important, because you can avoid distributions outright to an 18-year-old that without a trust you can't avoid. And when you have a trust, you can put in clauses about separate property. So if my kids are married, I can have them keep these assets, their separate property. So if they later get a divorce, the monies that they inherited are fully protected. So it is a nice thing to be able to include that type of language in your estate plan. Not everybody needs it. I've done planning for clients that have tortoises. Apparently tortoises live over 100 years, so they're going to outlive their owners. So I've had clients that want to make sure that their birds, tortoises, parrots are protected and not euthanized because their owner passes away. So I know for some people, they think that sounds kind of foolish. To me, it's very responsible to make sure that the people that are dependents on you are taken care of should you become incapacitated or pass away. So that's really what an estate plan is. An estate plan, like I said, is typically going to include your durable powers of attorney. The durable power of attorney for financial affairs is a document that gives a loved one powers over assets that are titled in your individual name, whereas assets titled in the trust gives power over those assets. So just going back to a prior example, if I were hit by a drunk driver, the way that my loved ones would know which document they should be using is how the asset is titled. So if I have a bank account that's titled in my individual name, you would use the durable power of attorney to have the power to manage and deal with that asset. But if I have an asset that's titled in the name of my trust, then it's the trust that gives legal powers and permission to deal with that asset. So when you were named as a trustee for a loved one, that's probably the most confusing thing to figure out when you first um, start acting on behalf of a loved one is which document do you use for what. So the first thing you want to do for financial matters is always look at how the thing that you're trying to deal with is titled. So if my car is titled in my name and my husband needs to sell the car because it's I can't drive any longer, since the car is titled in my individual name, he would use the durable power of attorney. Whereas if we're in the middle of a refinance on our house, because the house is titled in the trust, he would use the trust document to give him powers to sign my name. And it is important to note that when a person passes away, their durable powers of attorney die with them. So if I died, my husband can no longer use my durable power of attorney. So what happens at the time of your death is the will comes in and replaces the durable power of attorney document. So if I died yesterday, to not jinx anything, and if my car needed to be sold, because I am now deceased, my durable power of attorney no longer has legal power. It died when I died. So it's the will that's the document that would give my husband my legal permission as my executor to step into my shoes and gift the car to St. Vincent de Paul, sell the car, or put the car in his name or the kid's name. But if I died and if an asset was titled in the trust, it's the trust that gives him my legal permission. So anytime you are in a situation where you're named as a trustee and you're dealing with assets on behalf of a loved one, you want to look at how the asset is titled, because that's going to tell you between the two financial documents which one you're using. So when a person's living, it's the trust and the durable power of attorney that are in play. When a person passes away, it's the will and the trust that are in play. And when a person can't make medical decisions, it's the healthcare directive that's in play. So you have 4 estate planning documents, 3 are financial. The trust, durable power of attorney, and will are your 3 financial documents, and the medical document is its own separate document. Sometimes people will have the same people listed in the medical directive that they have in their financial documents, but it's not uncommon to have different people listed in different orders in the documents. But for the 3 financial documents, you need those nominations to match. And sometimes between a married couple, that's kind of tricky because it's one bucket of community property money. So it's not like the husband can have his sister as his durable power of attorney and the wife will have her brother. Spouses need to pick who that person's going to be for both of them. And sometimes that's hard. And I understand that, but just knowing that it's not uncommon if a spouse does become incapacitated or passes away for the well spouse to come back in and to do an update, because all of us want the people that are named in these documents to be the people that we're closest to. So you always have the ability to review and update these documents. And as I mentioned before, updating who your people are is the most common change that people make. So for that reason, I don't always encourage clients to share copies of these documents with their loved ones. What I would rather you do is keep these documents in a safe place and make sure that your loved ones know where these documents are located. So for example, our first choice trustee knows that we have an estate plan, but he's never read it because we change it from time to time. But he knows in our house where we keep that estate plan. It's only the medical directive that my husband and I shared with our loved ones, because the medical directive does have language in it that a copy will be treated like an original. So it is important to make sure that whoever you've entrusted to make your medical decisions has a copy of that medical directive. So that way, if, I've got my husband listed first as my healthcare agent, but if him and I are both hit by the drunk driver, it's good that my second, third, and fourth people also have a copy of my medical directive. My insurance information is copied and attached to it. They have that information. So if they get a call that there's a problem, they can grab their copy of my medical directive and take it to the hospital. And now they're in charge, and the hospital has all of my medical insurance. I also encourage clients, when it comes to their medical directive, to keep copies of those documents in the glove compartment of their car. So right now in my glove compartment, I've got my medical directive and my husband's. Once my kids are 18, I'll have copies of their directives in my glove compartment as well. Anytime I travel, I keep a copy of my medical directive in my suitcase, and I put the directive in plain view at whatever place we're staying, hotel, Vrbo, Airbnb. That honestly makes my husband super uncomfortable that I leave that document out in plain view. But really, if something happened to us while we were traveling, the only thing that the hotel knows about us is our name and our credit card number. So it's a good thing to have the medical directive in plain sight because it's got your medical insurance information, it's got phone numbers. It is the very thing that hotel or Airbnb would need to make some phone calls and start making things happen on your behalf. So having said that, it does surprise people that these documents are not public. Sometimes people just assume that there's some vault somewhere in San Diego County where all these documents are kept and they can just go there and request somebody's documents. Probably the hardest thing about my job is when a client of mine becomes incapacitated and their adult child just calls on the assumption that I'm just going to send them all of my client's documents. I can't legally send these documents to a third party without having my client's consent. Or if a client is incapacitated, I need a doctor's note stating that a client is incapacitated before I can provide a client's documents to a third party, even my client's adult child. So that is probably the hardest thing about my job because understandably in these difficult situations of a loved one losing their capacity, they need these documents and to start making the decisions. But I, as an attorney, because of attorney-client privilege, can't just hand these documents over when requested. Most people, once I explain, understand that, but that is a difficult situation. Another difficult situation we deal with is sometimes I'll have an adult child or a close family friend bring a client in, and I can tell that my client no longer has capacity. In California, if you do not have capacity, you are no longer able to update these estate planning documents. So for people, sadly, that have diagnosis of Alzheimer's or illness that will involve any kind of diminishing capacity, your window to put these documents in place or to update and review existing documents is now starting to close. So it's really important to make sure that if you have an estate plan in place that you're reviewing and updating it. And if you don't have an estate plan in place, if you get that diagnosis, it's really important to make sure that you get these documents in place. And if you think you might be moving out of state to live closer to a loved one, it would probably be okay if you waited and did the documents in the state that you're going to be living in because all states have different laws. These documents are valid throughout the United States, but to be honest, if you move from California to New York, it would be better to have the California documents updated to be interpreted under the laws of the state of New York because it's just going to be easier for those financial institutions that are familiar with New York laws to have New York documents. But just know, having said that, that the California estate plan is valid throughout the United States. It's just anytime these documents are presented in a state outside of California, there usually is a bit of a lull, for lack of a better word, because oftentimes those financial legal departments have to reach out to a counterpart in California that can explain any differences in the language or laws because all of these states have different laws, but the documents are valid throughout the United States. And then for clients of mine that have assets outside of the country, the United States does not have jurisdiction outside of its borders. So if you owned a house in Canada, for example, you'd want to have a comparable estate plan written under the laws of Canada to deal with assets in that country because our documents only have jurisdiction over assets that are located here. So I think that's a pretty good overview about estate planning. Like I said, if you have an estate plan, generally speaking, you want to review the documents about every 8 to 10 years because the language does get stale, for lack of a better word. If you have an estate plan and if you haven't shared copies of your medical directive with your loved ones, I would encourage you to do that. I even gave copy of our medical directives to our neighbor. He's not on our directives, but I just asked him if he ever saw an ambulance or a police car in the driveway, could you please give him these documents? And then he in turn gave us a copy of his. So you could even share your healthcare directive with people that aren't even named in the documents, just for the whole purpose of them being the conduit that's going to get the documents to the ambulance driver, to the firefighter, to the police officer. For those of you who have ARAG legal insurance, it's a great benefit that you have. If you haven't used it, I would encourage you to use it. Estate planning is covered under your insurance. We are the busiest October, November, December because ARAG is kind of a use it or lose it. So your hours from 2022 do not carry into 2023. So if you've been wanting to review an estate plan, update an estate plan, I would encourage you to make that appointment now, because if you make the appointment in 2022, even if you finish the documents in 2023, you'll use 2022 hours just because you got that case issued to you in 2022. So, and if you don't know if you need to do an update, but maybe you're thinking you might, just call ARAG and get the case assist so that you have those case assists issued in 2022, even if it carries into 2023, because that way you'll preserve all of next year's hours should you need them. So I know that there's open enrollment generally in November. I don't know if ARAG's being offered this year, but usually that's when you can sign up for it if you don't have it. But it is a great benefit. We've really enjoyed working with people that have it. It's very user friendly, and all that's done through ARAG directly. But anyhow, I think that pretty much sums up everything that I wanted to cover today. I'm going to look